All right, good morning. Welcome to the 294th District Court. My name is Judge Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present here. Raise your hand so I can acknowledge you as being present. Michael Bowman. Here. Giovanni Chavez Rosales. Joshua Chenault. Adam Cronister. Did I say that right, sir? Can you help me? Adam Cronister. Okay, I'm sorry, Mr. Cronister. This may not be the last time I say your name wrong, so I want to apologize for future mistakes. Randy Dobbins. Randy Lee Dobbins. Mr. Dobbins not here. Joshua Martin. Here. Tanya McBride. Here. Lena Price. Here. Carlos Gatlin. John McLeod. Here. Felix Diaz. Felix Alejandro Vasquez Diaz. Kalen Cheatham. Kalen David Cheatham. Eugenio Gonzalez Merlo.
Judge, I'm present on behalf of Mr. Gonzalez. I have not seen him this morning. I know he lives in Florida.
Okay. Well, we'll see if he appears and I'll recall him. Jonathan Ridnour.
He's present, Counselor.
Thank you, Ms. Harrison. Will that be a plea today, Mr. Harrison?
Yes, Your Honor. Very good. Clerk's office right there.
Great, thank you, sir. Jason Briggs. Kenneth Henderson. Sydney Hipp. Anthony Murray. Anthony Wayne Murray. Jacob Myers. Guy McSpadden. Andrea Young. Thank you, Mr. Thorson. Jan Espino. Daniel Payne. Mary Robinson. Isaiah Valencia Fulton. All right, is there anyone who's present in the courtroom and I've not called your name? See no hands. Do we have any counsel that's ready? Mr. Manning?
Judge, I'll make that hearing for Ms. Fulton and Mr. Noriega. I'm sorry, say that Fulton.
All right, go ahead and bring him up. Isaiah Valencia Fulton. And you said you're making an appearance.
Yes, Judge. Mr. Noriega, when he scheduled a recent last time, was unable to check his schedule and he was out of town. So he asked for me to appear. I believe it's set for arraignment. They did arraignment in the last setting, so if we just reset the pre-trial, so he has time to go under.
Well, he's got one set for arraignment and then he's got two set for pretrial. Okay. He's got an ag assault F2 and a driving while intoxicated Class B. Now I have Miss Sally Wilton as counsel. You're representing Mr. Noriega.
Judge, my understanding is that Mr. Noriega works with this.
You know, and Mr. Manning, I know you're standing in, but do you know if they filed any pretrial motions?
I don't believe they filed any pretrial motions at this point in time.
All right. And you said that you do believe that Mr. Fulton was arraigned on the CR 2320 ag assault.
That's correct.
Trying to figure out why I have it set for arraignment. It's already been arraigned. And you know he has two ag assaults, right?
I was unaware of that.
He has an ag assault that he was arraigned on at the same time he was arraigned on his driving while intoxicated, but he has three causes: CR 2320, CR 2321, CR 2323. Now, both ag assaults appear to be consecutive in numbers. I'm not sure why we would have arraigned on one and not the other, but give me a moment. Let me check the clerk's file. Yes. All right, Mr. Manning, I show that Mr. Fulton was set for pretrial today on all three of his cases. So what I'll do is I'll just, I'm gonna go ahead and set Mr. Valencia Fulton for docket call. I don't see where any pretrial motions were filed. I don't state, are you aware of any contested pretrial motions?
No, you're on.
I'm trying to confirm that in my e-file, but I'm not having luck at this time. If no pretrial motions were filed, the court's going to set it for docket call.
When date will that be, Judge?
Let me just confirm the e-file. Do you have his or her schedule availability at all?
I believe that we were looking at the 25th of April.
All right, I've checked e-file. I see no filings for these cause numbers. So the court will set Mr. Valencia Fulton for docket call. April 25th. That'll be at 9 a.m. And Mr. Fulton, once you sign and get the yellow copy, you're free to go, sir. All right, Mr. Harrison, you ready?
Right, let's score it down.
All right, court calls, cause number CR 22391, CR 2386, State versus Jonathan Michael Ridenour. And for plea.
Yes, in the PTI, Judge.
PTI is on the B misdemeanor.
PTI is on the felony.
Felony.
Yes.
All right, Mr. Ridnour, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Thanks, sir. You can lower your hand. Just make sure you speak up loudly and clearly for me during this plea so I can hear you, and so my court reporter can take down what you have to say, okay? All right, Mr. Ridnour, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
And have you ever been diagnosed with a mental condition?
No, Your Honor.
In this case, you are represented by your attorney, Mr. Brett Harrison. Are you pleased with Mr. Harrison as your attorney?
Yes, Your Honor.
Do you feel like you've had enough time to talk with him about your cases and that you've had all of your legal questions answered?
Yes, Your Honor.
Is there anything about the paperwork that you've read over and signed today with Mr. Harrison that you do not understand?
No, Your Honor.
Mr. Harrison, do you believe your client to be competent today?
I do, Your Honor.
You've explained to him his rights as they pertain to each one of these plea agreements and with specific regard to the terms and conditions of the pretrial intervention contract.
I have, Your Honor. I've also discussed this with his administrative attorney, in Austin. So he's for the back.
Okay. All right. Mr. Ridnour and cause number CR 22391. You are charged by indictment with a state jail felony offense of possession of a controlled substance of penalty group 1 less than 1 gram. The range of punishment for a state jail felony, if convicted, sentence would be for not less than 6 months or more than 2 years confinement in a state jail division of TDC, and an optional fine, if imposed, not to exceed $10,000. In cause number CR 23-86, you are charged by information with a Class B misdemeanor offense of possession of marijuana less than 2 ounces, which carries a range of punishment of up to 180 days confinement in the county jail and a fine not to exceed $2,000. I see that there's a plea agreement in both of your cases. In regards to the felony possession case, I see that the proposed plea is that you would enter into a pretrial intervention contract with the state for a period of 2 years under the terms and conditions of that contract. Is that your understanding, Mr. Ridnour?
Yes, Your Honor.
And you understand that as specific terms and conditions of this pretrial intervention contract, there are very important rights that you would be waiving and giving up today. You understand that?
Yes, Your Honor.
Specifically, you are waiving your right to a jury trial, which no one can take away from you. Do you understand that?
Yes, sir.
You and only you can waive that right. Mr. Harrison can't do it. I can't do it. The state can't do it. You and only you. And if you waive your right to a jury trial, that right may not be restored to you later, meaning if you change your mind or you have buyer's remorse, you may not get that back. Do you understand that?
Yes, Your Honor.
And if you give up your right to a jury trial, you are waiving your right to confront the state's witnesses, confront their evidence in front of a jury.
Yes, Your Honor.
And has anyone forced you, threatened you, tried to convince you that you had to waive your right to a jury trial today? Are you waiving your right to a jury trial intentionally, knowingly, and voluntarily?
Yes, Your Honor.
You're also giving up your right to a speedy trial, and you're also giving up your right for a limited waiver of expunction of certain records. Those records belonging to the DA's office and the probation department. If you successfully complete the terms and conditions of the contract, there will be records that you can have expunged. But the records that you would not be able to have expunged due to your waiver would be the records of the state, and that is the DA's office and the probation department. Do you understand that?
Yes, Your Honor.
Now, with regard to CR 2386, charge of possession of marijuana, I see that the offense, or that the plea agreement to the offense is that you would plead guilty to that crime in exchange for the state's recommendation that your punishment be assessed at 6 months confinement in county jail, with that being suspended and you being placed on probation for a period of 2 years, a $1,000 fine plus court costs and reimbursement fees. And the state would be dismissing under section 1245 cause number 2022-405, which is an open container in motor vehicle. Is that your understanding, Mr. Ridnour, of the plea agreement in that case?
Yes, sir.
All right, then with regards to the possession of marijuana less than 2 ounces, how do you plead to that crime?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today? The court will accept Mr. Ridnour's plea of guilt in this cause. Mr. Harrison, any objection to the state's evidence?
No.
State's evidence is admitted and the court takes judicial notice of Mr. Ridnour's judicial confession. The court also finds that Mr. Ridnour has, with regards to the possession of controlled substance case, has signed the pretrial intervention contract, has stipulated to the admissibility of the evidence as a term and condition of his community supervision. Should this case be returned to the court's trial docket, court finds that Mr. Ridnour has intentionally, knowingly, and voluntarily waived his right to a jury trial, right to a speedy trial, and has executed a limited waiver of expunction. The court is going to review the evidence this time in the pretrial intervention case. All right, the court will approve Mr. Ridnour's placement into the pretrial intervention contract program. Court approves Mr. Ridnour's waiver of jury trial. Court finds that the state has waived its right to a jury trial. Is there anything further from the state with regards to either case? Thank you, Mr. Harwell. Anything further from the defense?
No, Your Honor.
All right, in reviewing the evidence, court finds that there is sufficient evidence to convict Mr. Ridnour of the possession of marijuana case. Court will follow the plea agreement, cause number CR 23-86. Court hereby convicts Jonathan Michael Ridnour of possession of marijuana less than 2 ounces. Court will assess his sentence at 6 months confinement in the county jail. The court suspends that sentence, places Mr. Ridnour on 2 years community supervision, orders him to pay a $1,000 fine, $270 court costs, $15 reimbursement fees. The court dismisses under section 1245, cause for 2022-405, open container motor vehicle. Court's also signing the motion order granting the motion to dismiss on the unadjudicated 1245 offense. Mr. Harrison, the trial court certification of the defendant's rights to appeal was signed by you and your court, but there was no indication up here. The court has checked off that it is a plea bargain case. The defendant has no right to appeal, and also that the defendant has waived the right to appeal. And I'll need someone from the state to sign this. One place here. There's the warden certification. Thank you. All right, Mr. Ridnour, you are hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward. You're gonna be fingerprinted by the bailiff, and then you'll report to probation. They'll give you more information about the next steps.
That's all. I have no issues.
Yes, thank you, Mr. Harrison.
Have a good day.
You too. Tell Mr. Files I said hello with him.
Yes, sir. Yeah, coach, I don't think it's always matters.
Just a moment, Mr. Oldham. I think we're ready for your Spanish speaking client.
Yes, sir.
Let me get the interpreter taken care of. Let's see.
Judge, do you have papers of arraignment? Let's do it on the record.
No, we'll just do it on the record. Good morning, Mr. Montemayor. How are you, sir? Now, if you want me to read lips, we're gonna be in trouble.
No, sorry, I forgot to take off the
Let's see,
mute.
I'm still not getting you. I don't know if it's a me issue. Can you hear me okay?
I can hear you.
Can't see. I'm not getting any audio from you. Make sure, let me go ahead and add you as the interpreter. Let me go ahead and do my setup and then we'll figure it out.
Okay.
All right, try me now. No, sir, just reading your lips. Say something again. Let me see if Zoom is picking you up on a microphone feed. No, and I don't see your microphone recording through Zoom, picking you up. Okay, I think I got the gist of what you said. And Ms. Tabraham, we're having some difficulty with the OCA interpreter, so I think he's gonna log out, and log back in. So just let's hold what we got.
Can you hear me now?
No, sir, I cannot.
Hmm. Test, 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 test.
Wait, now do me a favor. Go back to your computer and then just say something on here so we make sure it's not
Test,
our issue.
test.
Right, everybody can hear me, but it could be a speaker issue for me where I'm not hearing people.
Testing 1, 2, 3. Can you hear me?
All right, it appears it is a speaker issue for me because I can see Ms. Barker's microphone moving, but I do not have any audio.
Judge, I did do an update today.
Yes. All right, Mr. Mayor, Mr. Montemayor, say something now.
Test,
Yes, there-
test.
so just like a bunch of old girlfriends, it's not you, it's me. Okay, so apologize for that.
They can hear the interpreter on YouTube.
Yes, it was me, the speaker. That's what I was telling him. It's not you, it's me. All right. I was hoping it was Mr. Montemayor. I don't like to be the problem.
We can always say it wasn't me, Your Honor.
That's right. It's not always true. That's what's bad about it. All right, I think we're getting Mr. Diaz hooked up. All right, Mr. Montemora, have you spoken to Mr. Diaz to make sure we have connectivity?
Señor Díaz, ¿puede escucharme? ¿Sí me puede escuchar? Okay, yeah, he can hear me, Your Honor.
Are you switching over to the Spanish channel for him? Because we have him in headphones.
I will need you to put me once again as interpreter because I just rejoined the session.
Gotcha. I think I've done that correctly. All right, great. Thank you, sir. All right, court calls, cause number CR 23-28, State versus Felix Alejandro Vasquez Diaz. At this time, I'm going to ask my licensed court interpreter to take the oath. Mr. Montemayor, if you'll raise your right hand and go ahead and state your name and license number. You go ahead and state your name and license number. Mr. Montemayor, do you swear or affirm that you will make a true translation of the statements of the court, the questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? And I didn't pick you up for the record. All right, thank you, sir. You can put your hand down. Okay. All right, I show today, Mr. Alton, that Mr. Diaz is set for arraignment on the charge of evading arrest or detention with a vehicle, third-degree felony.
Yes, Your Honor.
All right, has he reviewed the indictment? Is his name spelled correctly?
Yes.
All right, and so he's waiving the formal requirements of arraignment.
Correct.
All right, court will find that Mr. Diaz has reviewed the indictment in this matter with counsel, Mr. Alton, that he's waived the formal requirements of arraignment, that his name is spelled correctly in the indictment, and the court will enter his plea of not guilty into the record and will set this matter for pretrial hearing. Mr. Alton, are you available on May 9th?
I am.
All right, court sets Mr. Diaz to return to this court for a pretrial hearing on May 9th. That will be at 9 a.m. And Mr. Alton, Mr. Diaz will need to sign his conditions of pretrial release. Those are going to be the conditions. I'm going to explain this since we have Mr. Montemayor with us to help translate to Mr. Diaz. The conditions of pretrial release are going to be conditions that Mr. Diaz has to comply with while he is on bail. In this case, it's pending. He will get a copy of those and he'll have to report to the pretrial release department as soon as our hearing concludes over here through this jury room to his left and my right, and they'll give him more information. There may be a language barrier there. I think that they will try to bridge that as much as they can. But if he has any questions, he needs to speak with Mr. Alton, and perhaps we can get him taken care of. Does Mr. Diaz have any questions, or is there anything he does not understand?
No, bueno, lo que pasa que yo tengo esas condiciones en otra ciudad.
Let him know that I understand that, but he's gonna have conditions in this court that he has to comply with because the conditions in the other
Okay.
city do not affect this case. And also, I would like to know if Mr. Diaz has anyone with him today that could help translate between him and the pretrial release officer.
No,
Okay, all right, then we'll do our best to bridge the language gap. All right, Mr. Diaz, do you understand that you're ordered to report back to this court on May 9th at 9 AM?
sí, sí.
Okay, then once you sign and get the yellow copy, then I want you to step back here. This is Mr. Waddell. Mr. Waddell. This is Mr. Diaz. He's going to sign conditions of pretrial release today. He is a Spanish speaker and he does not have anyone with him to help translate with your department. So apologize for that, but I told him to report to you at the conclusion of this hearing.
We've already been. Started on that process.
Are you fluent in Spanish yet?
No.
Can you get there?
I will take him to Mr. Land.
Okay, so you're gonna pass him on to someone else. So you don't want to take on learning the Spanish language.
I'm working.
Okay, all right.
Gracias.
All right, if there's nothing further, then Mr. Diaz, get your yellow copy and then go see Mr. Waddell.
I believe that's all I had.
Yeah. Yes, Mr. Waddell. While we have Mr. Montemayor, do you want me to have him explain to Mr. Diaz where to go to probation and to ask for? You'll take him. Okay, thank you. All right, Mr. Montemayor, I believe that's all that I have on your docket this month. Great. Well, I'll try to have all my ducks in a row when I get back on. All right, great. We'll see you this afternoon. Thank you, sir. We have any other counsel that's ready? Mr. White, you ready?
Yes, sir.
Who would you like to call first, Payne or Robinson?
Let's call.
Daniel Ryan Payne, CR 22-246. Mr. Payne set for docket call.
Your Honor, this is Mr. Fluke-Black's case. I can provide him some additional information on this. I'm gonna ask the court if we could have a final document. And I think that will further make it close.
Any objection from the state?
No, Your Honor, my notes indicate, same.
Okay. All right, then the court will grant Mr. Payne a final docket call on April 25th. That will be at 9 AM. And Mr. Payne, once you sign and get the yellow copy, you're free to go. Mary Robinson, CR 22-194.
Your Honor, we're setting for docket call with Robinson. Ms. Curry and I have been discussing this case, and I had during the course of our discussions, a couple of issues. Came by, she wanted to talk to the trooper regarding some things we talked about. She indicated to me this morning she had not been able to talk with the Cosmo just yet on that. I would ask the court to reset this. I don't believe Ms. Kirby has.
Stig?
No objection.
All right, can we set that for a final docket call? And you believe that you still have other things that you're working on?
My intention was today to make a final announcement. But we kind of got some discovery of this, no fault of the district attorney's office, but we got a discovery kind of piecemeal. And so when we finally sat down and talked about it, that's why there's kind of been this delay, because there was some issues with a couple of interviews in a report that we didn't have before. And then when I got those documents and then the interviews, viewed them, some of the issues that I viewed to be present in the case, like where sometimes the DA don't agree on every issue, but those, I think I was able to express what I was thinking clearly, Ms. Curry. So I believe that that should be sufficient.
All right, court will reset Ms. Robinson for docket call on May 9th at 9 AM.
That's all I have.
Thank you, Mr. Rock. Nothing this afternoon? You've managed to stay out of jail like the last several.
I have. That's my goal.
As is your client, right? Mr. Thorson, you ready?
Yes, sir.
All right, this is CR 22-121, State versus Andrea Young for docket call. Mr. Thorson, any announcements?
Your Honor, I don't mean. Trying to discuss this, really, I guess last time. Plea agreement, she's very good at this, the case for trial.
Okay, does she understand that the court may not entertain a plea after today? Meaning that whatever the offer is today may not be available to her the Friday before a jury selection?
Yes, Your Honor, we've discussed that. This is a case that may end up for me. This is where I'm in trial.
All right, court will set Ms. Young for jury selection beginning May 1st. Now, Ms. Young, on May 1st, when you report, you will not go to trial on that day. You will enter into the court's rolling trial docket. And so you will be at the bottom of the list. You will continue to report to the court each month until your case reaches the top 10 and becomes liable for trial. So that means that Mr. Thorson's not going to be required to be here. You're going to report at the lower floor, and my staff will be there, and they will give you the reset date. You'll sign, check in with the pretrial release officer, and then you'll leave, and you'll continue in like manner until the case is reached for trial. Okay. All right. All right. So we'll see you back on May 1st for jury selection. Once you sign and get that yellow copy, you're free to go. Thanks. Good morning, sir. How are you doing? Yes. Who would you like to call first, sir? Jacob Wyatt Myers. CR 2330 for arraignment. All right, court finds that Mr. Myers has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record. Court sets this matter for pretrial hearing. It's May 9th, suitable. All right, court sets Mr. Myers for pretrial May 9th. And Mr. Schmidt, Mr. Myers will need to sign his conditions of pretrial release if the probation department hasn't already presented that to him. So he'll need to meet with Mr. Monday. Court calls cause number CR 22379 and 2022-432 State versus Sydney Kyle Hibb for docket call.
That's correct, Judge. We've reached the agreement with the state. I know Mr. Woodward is having a submission.
All right, court sets Mr. Hibb to enter his plea before the court on May 9th at 9 a.m. Mr. Hibb, I show that you're delinquent in your pretrial supervision fees. I know say $120. Did you come prepared to make a payment? All right, I want you to go over to the probation department and pay that as soon as you leave court, okay? Jason Briggs, CR 22370. Docket call, burglary of habitation. Any objections from the state? Any objections to Mr. Schmidt's request for an additional docket call? All right, there being no objection from the state, court sets Mr. Briggs for a docket call May 9th at 9 a.m. And once he signs, he's free to go. You may. Kenneth Henderson. All right, Mr. Henderson, this is cause number CR 22325. You are Kenneth Drum Henderson, correct? Mr. Henderson, sir, if you'll raise your right hand, I'm gonna place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. Thank you, sir. You can lower your hand. Just speak up loudly and clearly for me. Mr. Henderson, are you a United States citizen who reads, writes, and speaks English? Have you ever been diagnosed with a mental condition? In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney? Do you feel like you've had enough time to talk to him about your case, and that you've had all your legal questions answered? Is there anything about the paperwork that you've read over and signed today with Mr. Schmidt that you do not understand? Mr. Schmidt, do you believe Mr. Henderson to be competent to enter into this plea? And you've explained to him his rights as they pertain to this plea agreement. Yes. And you believe that he understands those rights and he's entering into this intentionally, knowingly, and voluntarily? Yes. Mr. Henderson, you are charged by I think the judgment says charged by information, but in fact, it is an indictment, correct? That's correct. All right, so state, we'll need to get that, since it's a TDC plea, we'll need to get that fixed to say indictment. Mr. Henderson, you are charged by indictment with the third-degree felony offense of driving while intoxicated, third or more offense. The indictment also alleges an additional felony enhancement paragraph. It's my understanding that the state is not proceeding on the enhancement paragraph. So the range of punishment for your third-degree felony offense would be no less than 2 years in prison and no more than 10 years in prison, and a fine of not more than $10,000. I see that the plea agreement in your case is that you would plead guilty to that offense. The state's recommending that your sentence be set at 8 years confinement in prison with a $1,000 fine plus $290 in court costs, $60 in reimbursement fees, and you would receive 95 days credit towards that sentence for the time that you've already spent in jail on this cause. Is that your understanding of the plea agreement, Mr. Henderson? And that's what you're asking the court to approve today? All right, Mr. Henderson, I've explained the range of punishment. I've explained the plea agreement. So at this time, how do you plead to driving while intoxicated, third or more offense, a third-degree felony? Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason? Has anyone threatened, forced, or pressured you to plead guilty today? The court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the state's evidence? All right, state's evidence, stipulation one, or stipulation of evidence in states one is admitted. The court takes judicial notice of the defendant's judicial confession. Anything further from the state? Nothing further. From the defense? No. All right, court's going to review the evidence. All right, the court has reviewed the evidence, finds that there is sufficient evidence to convict Mr. Henderson of this offense. Court will follow the plea agreement in this case. The court hereby convicts Kenneth Jerome Henderson of driving while intoxicated, third or more offense. Court assesses his punishment pursuant to the plea agreement at 8 years confinement, Texas Department of Criminal Justice, Institutional Division. Court orders a $1,000 fine, $60 restitution, $290 court cost. Or hereby awards Mr. Henderson 95 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Henderson, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you come forward with Deputy McLeish here, and she's going to take your fingerprint, and then she's going to take you into custody. You got anything to add, sir? Oh, yes, sir. Yes, sir. Right, Estrada, did you need to approach or you? good?
Yes, we can approach your honor.
All right, come on up.
It's only
Well, all right, Mr. Espino is set for docket call.
Your Honor, after speaking with the state, I believe we're needing another docket call in this case.
We're still carrying this case forward, is that correct? Waiting resolution of other cases.
Yes, Your Honor, there's one other code that we're waiting to have a jury trial.
Do you know off the top of your head what date we have?
In that case,
On that case? I have mine. I may have it here.
it looks like December 4th, Judge.
All right, Mr. Espino, I'm gonna set you out a little bit further. I'm not aware of any condition issues on pretrial release. So today being April 4th. I'm gonna have you come back on Tuesday, July 11th. Are you available that day, Mr. White?
Let me check, Your Honor.
No, that's the middle of July, so check vacation and stuff.
Well, actually, I believe I was gonna be at a seminar in South Padre Island. And I never wanted to learn something so bad.
I bet that's true.
And I'm not sure if it's the 11th.
All right, what about, what if we go a little bit earlier and say Thursday, July 6th?
Could I can choose?
The 4th?
No, I guess we better not.
You would make it July 4th? I can make sure that you're first on the docket. You'd be the only one on the docket.
July 6th would be fine.
All right, Mr. Espino, you're ordered back before the court July 6th, 9 AM. Make sure you stay in contact with your pretrial release department. Okay. That all you have today, Mr. White?
I believe so, yeah.
You have anything this afternoon?
No, I don't. Judge, we still have the jury on the,
This month?
of this month.
As far as I know. As far as I know. State hasn't put me on the class.
Well, I'm on jury.
Oh, you're on jury duty? Well, I'll get you on jury. I'll make sure that happens.
You have jury duty on you? Yes, it's,
In this court?
yes.
Oh, good. Good, bring your business cards.
That's
Mr. Stevens, you ready?
Yes, sir.
All right, Mr. McSpadden, we'll try again. All right, this is cause number CR 2236, State versus Guy Ezekiel McSpadden. Mr. McSpadden, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, Your Honor.
Thanks, sir. Lower your hand. Mr. McSpadden, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
Yes, Your Honor.
Can you tell me about that?
PTSD.
Are you currently on medication or undergoing treatment for PTSD?
Yes, Your Honor.
Do you feel like today your PTSD is in any way affecting your ability to understand the proceedings and what's going on in this case?
No, Your Honor.
And Mr. McSpadden, you are represented by Mr. Stevens. Are you pleased with Mr. Stevens as your attorney?
Yes, Your Honor.
Do you feel like you've had enough time to talk with him about your case and that you've had all of your legal questions answered?
Yes, Your Honor.
You've signed some paperwork today with Mr. Stevens. Is there anything about this paperwork today that you do not understand?
No, Your Honor.
Mr. Stevens, do you believe that Mr. McSpadden is competent today?
Your Honor.
And you haven't seen any signs or symptoms that his PTSD is in any way affecting his ability to comprehend the plea agreements and understand what's going on in this case?
Yes, sir.
Do you believe that he's entering into this plea intentionally, knowingly, and voluntarily after having been advised of all of his rights?
Your Honor.
All right, Mr. McSpadden, you are charged by indictment with aggravated assault with a deadly weapon, a second-degree felony. Court finds that the range of punishment for a second-degree felony offense such as this is, if convicted and sentenced, would be to a range of punishment that must not be less than 2 years in prison or more than 20 years in prison, and a fine, if imposed, not more than $10,000. I see the plea agreement in your case is that you would plead guilty to that crime. The state would be recommending that your sentence be assessed today at 8 years confinement in prison, but the state's also recommending that that sentence be suspended and you be placed on probation for a period of 5 years with a $2,500 fine, $290 in court costs, $35 in reimbursement fees. And there's a weapon forfeiture that is part of the plea agreement. Is that what you understand the plea agreement to be, Mr. McSpadden?
Yes, Your Honor.
All right, then understanding the plea agreement and the range of punishment, Mr. McSpadden, how do you plead to aggravated assault with a deadly weapon?
Guilty, Your Honor.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, Your Honor.
Now, I saw some hesitation. And you understand that when you stand before the court and you plead guilty, that you're telling this court that you are legally responsible for this crime. I can't let you plead guilty just because you want a probation sentence or you think that this is your only option. I need to know that you're pleading guilty to this crime because you are legally responsible and guilty of committing this crime. Is that true?
Yes, Your Honor.
All right, thank you, sir. All right. Court will accept the defendant's plea of guilt. Mr. Stevens, any objection to the state's evidence?
No, Your Honor.
State's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, I believe, besides, I just wanted to make it off the record that the MDE partners are on board with the recommendation.
Okay. And do we have victim notification and compliance?
I believe so, yes.
And do we have any idea if the victim is supportive or not supportive of the plea?
If you're not looking at just.
Sure.
She is supportive, Your Honor.
I think,
It is a family situation. There's a lot of family dynamics. She's supportive of this resolution.
thank you, Ms. Curry. Anything further from the defense?
Yeah, Your Honor.
All right, court's going to review the evidence. All right, court has reviewed the evidence, finds that there is sufficient evidence to convict Mr. McSpadden of this offense. Court will follow the plea agreement on the recommendation of the state. Court hereby convicts Guy Ezekiel McSpadden of aggravated assault with a deadly weapon, a second-degree felony offense. The court assesses his punishment at 8 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence and place Mr. McSpadden on 5 years community supervision. Court orders a $2,500 fine, $290 court costs, and $35 reimbursement fees. Ms. Curry and Mr. Stevens, can you all approach real quick? Mr. McSpadden, we're gonna recall your case. There's some issues with the paperwork. We're gonna get those corrected, and then we'll come back and we'll talk about everything again, okay? Yes, Your Honor. Mr. Adams, you ready? Yes, sir. And Mr. Estrada, I do see someone in the waiting room. It's logged in as a Samsung. I don't know if that's your client or not.
I believe so. My office just messaged me on Microsoft Teams stating that he is waiting.
Okay, all right. So after Mr. Adams, then I'll bring your client in. Good.
Yes.
All right, Mr. Adams, who would you like to call first? All right, Carlos Gatlin, CR 21288. Mr. Gatlin is set for docket call today.
Yes, Your Honor. Morning, Ms. Adams. Last year, August of last year. Since then, now it's not been on the docket. My notes tell me. My files tell me we were working on getting a copy of relevant dash cam. Did not have editors, and that dash cam footage. Help me to discern whether or not I can file a motion to suppress based on cause stop. I have checked, you have that video footage. I have not viewed it yet, because Mr. Gallen's case has not been on the plate. So I would ask first of all, just to sense or to turn not too far. So I'll have the opportunity. File that motion.
Looking back over the history of this case, I see that he had two pretrial hearings in November of 21, February of 22, and then he's had 1, 2, 3, 4, 5. Today is the 6th docket call, and then he didn't appear in court, and so when he missed court, then his bail was forfeited, and the nine-side capias was issued in the summer of last year. So I feel like if we'd be setting for pretrial, we'd be moving backwards in this case. Is there any reason why we didn't take up any of this stuff in 2021?
Your Honor, there was some difficulty getting a copy of the dash cam footage. And it's usually, I will represent the court that I just got now, since that's not the case. In our office now, for several months or so. But Mr. Gallen's case on the docket is passed. I had taken time to stop and look at it. That's, there are other things to do.
Okay, so what we'll do, I'll set him for a final docket call. Are you available on April 25th?
Yes.
All right, we'll set him for a final docket call, April 25th. If between now and then you feel it's necessary to file a motion to suppress, file that. I'll let you argue on the record for the good cause, and the court will consider that, and then if the court grants it, then we'll set it for evidentiary hearing.
Yes, sir. I'll have that file. I know that I would need to. After next.
That sounds like a plan. Mr. Estrada, I don't see your client in there anymore.
You don't see it there, Judge. It may be because it's probably changed and
Okay,
changed his name.
well, if he gets back in there, I can change it for him, so.
Yes, no.
Yes, ready to go. John McLeod, CR 22334. All right, Mr. McLeod, set for pretrial.
Yes, Your Honor, we do the Janet on behalf of Mr. McLeod, we do have a double trial. Since we were last here, it's come, it came to my attention that the alleged victim in this case has been the subject of this investigation past, so file a motion for this to the investigation. Also filed a motion for discovery of child access records. Yes, among other things. Certificates, graduation records, Dauphin County Children's Access Center. And copies of police guidelines for protecting interviews of children. That's chapter 22. That's by any organization, three lists of Dauphin County Children's Access Center. I anticipate that for grants, that motion, child advocacy. That, those records to someone qualified to sign on CAC. So I'm asking the board to make those two motions. In respect to potential. I'll have to follow a motion to that.
Now, you said you're looking for policies, certifications. Is it anything with regard to the video or the
Your Honor,
certification of those individuals in the interview, or is this more about the accreditation and policies and procedures of the Children's Advocacy Center?
the video is what it is, and so I mean, I think CAC centers, any records that I don't already have regarding this, I should have. Well, of course, something more general, I would liken it to the DWI blood test discovery motion for asking for the records of the maintenance of chromatograph. Machine. Just as blood test, that's or breathalyzer test for maintenance records. Breathalyzers. Here I'm asking for the records that document child advocacy centers accreditation and guidelines, procedures, protocols that they always follow. So then I can compare what happened. Have third decisions followed by third party. Look at compare. Video and juxtapose it by accreditation protocol.
Are those records readily available online or by request? Here's my concern is Children's Advocacy Center is not a state agency. It's not an extension of the state of Texas. Unlike DPS and blood testing agencies. I'm not sure that the court can order a third party nonprofit to do those things. I'm not sure that I have jurisdiction to do that. I'm not sure that the state would be required to produce that, but more so I'd wonder if those things are not just readily available to the public online or direct request from the defense to the agency.
Oh, no, if they are. Right. I have other, if I can, that solves that problem. That addresses the issue. If they're not. Considering that's. Else, just servants. I wouldn't want those. I wouldn't want those records just not allowed trial.
State have a position on Mr. Adams' request.
Yes, Your Honor, Ms. Heisel, didn't have time to, she wasn't served with motions. She became aware of them, and taking the lead last week. So she just was going to ask for a reset, before ruling on these motions, but in the meantime, she wanted to, talk with Mr. Adams and perhaps be able to resolve it, with Mr. Adams before a reset. That's fine, that's brought on the case to be on March 16th, I'll follow March 16th.
I think we're pretty nailed down on how we're handling CPS records this day, the in-camera review. So, but the request would need to be narrowly tailored to a specific time frame regarding specific actors in order to allow the Department of Family and Protective Services to do a records review so that they can produce records timely that are responsive and then to the court the court to conduct the in-camera, so. I don't see a concern with that from the court, but I would ask the defense and state to work together to narrowly tailor what it is that's being requested and why, because those are confidential records. But in regards to the CAC records, I do want the defendant and state to talk about that. If the state wants to just provide that, that's great. They may be willing to do that, I'm not sure, so I'm gonna ask y'all to confer on that. I'll reset today's pre-trial hearing. Give y'all time for besides we'll get back in town. Perhaps these issues can be resolved by agreement. And if not, then we'll conduct another hearing and I'll address whether or not we can order the CAC to produce those things.
For what it's worth, the thing with respect to CBS, giving us message or I don't believe it's all about the same.
That would certainly help. Okay. And then, yeah, that request will need to be made with a specific date of allegation so that they can put some parameters around that search, just in case there's not. All right, so let's look at our calendars here, Mr. Adams. What if we come back on April 25th? That gives us 3 weeks, doesn't set it out too long, so that we can have some movement.
As it happens, Your Honor, I'll talk about it.
Excellent. All right, court will reset. Mr. Cloud for April 25th at 9 AM, and we'll take up CPS records and CAC records. Sounds good. You're welcome.
That's all I have. Warning up.
Do we see you for the afternoon docket? I'm assuming. You can hardly wait. It'll be fun and exciting. Sean, I don't see anyone in the Zoom.
You should be logged back in, but it doesn't allow us.
Adam Cronister, CR 2326. All right, Mr. Cronister, ma'am, you can't come up here. No, you have to go back behind that front row. Hold on. Mr. Cronister, this is CR 2326. You are charged by indictment with a third-degree felony offense of evading arrest or detention with a vehicle. If convicted, carries a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a fine could be imposed on you of not more than $10,000. Do you intend to hire an attorney or request a court-appointed attorney?
Yes, sir. I'm actually talking to the attorney, I just need, a little more time so I can fully afford it.
Okay, Mr. Cronister, if I reset your case to Tuesday, May 9th, that would give you a little more than 30 days. Do you feel like that'd be sufficient for you to retain Mr. White?
Yes.
Okay, all right, court's going to reset Mr. Cronister for May 9th for arraignment and status on hiring an attorney, whether it's Mr. White or some other attorney, I'm not concerned with, but I want you to come back with an attorney on May 9th, okay?
Yes, sir.
And hang on, you're gonna fill out a notice of appearance. We're gonna give you a reset that's gonna have that on there. And then, Mr. Cronister, you're also going to sign conditions of pretrial release today because you are on bail in this case. Court's gonna impose conditions on you. You're gonna report to the pretrial release officer. You'll be drug tested. You're not gonna be allowed to commit any more offenses. If you violate any of the terms of that pretrial release, I can find your bail to be insufficient. In this case, I can revoke your bail and put you back in jail. Okay? So I want you to sign with Deputy McLeish here, this notice of appearance with a reset date. All right, Mr. Cronister, come on back here. You're gonna meet with my pretrial release officer. And you can, are you mom? You can wait out in the hallway. He'll come out this way in just a moment. Thank you. All right. You're- Joshua Chenault, CR 23-8. All right, Mr. Chenault, this is your second hearing on hiring an attorney. Did you hire an attorney? How much time is a little bit more time? Another month. Why should I give you another month? How much money have you saved up? And how much is it gonna cost you? Okay, so you're 500 away? And who have you talked to?
Another attorney. Dallas. Haven't decided which one.
All right, Mr. Chenault, I'm gonna give you one last setting. I'm gonna set you again in 3 weeks to April 25th. I need you to have an attorney on that date. If you come back with an attorney, you might want to bring your toothbrush. If you come back without an attorney, you might want to bring your toothbrush with you.
What date was that, Ron?
April 25th. All right, you're free to go. I see him now. Go ahead and step up. Tell you what. Do me a favor, will you just take that laptop and put it right there by Mr. Estrada's speaker, so it's fine. Mr. Gonzalez, can you see and hear me? I don't believe he has any audio, Mr. Estrada. I don't believe he can hear us.
Mr. Gonzalez, can you hear us?
I don't show that he has his audio enabled for whatever device he's on. It's most likely that headset he's wearing. It's gonna cause a problem.
Chat message right now. Please turn your audio. Can you hear us?
Speakers are still working on my end. Mr. Gonzalez, can you hear us? Sent him a message. I told him that I was gonna remove him, put him back in the waiting room. Bring him back in, bring him back in, he needs to enable his audio device. It's now suggested that he not use that headset, because sometimes the headset throws everything off, so. We're gonna see if this works. Yes, well, you can't hear me, so. All right, I went ahead and just removed him. Do me a favor, call your office, have them work out the kinks with him. Tell him not to have his hat on and tell him not to use the headset. I told him not to use the headset, but he still had it on. Tell him just to use his regular phone. Don't put that headset on, take the hat off, and let's try it again.
No. It's not even decent.
All right, so we need to change this still. It still has the affirmative finding on the deadly weapons. So we need to get rid of that. Sorry, bitch. Oh, no. Mr. Stevens, can you have sign? Have it, I'll tell you what, I'll just swear. I'll just swear.
Apologize, Judge, I'm listening.
Here you go, Brad. Let me give you this. State needs to sign this. Yes, sir. Michael Bowman. All right, this is cause number CR 23-5, State versus Michael Dwayne Bowman. Mr. Bowman, have you hired an attorney?
No, sir, I'll try to go with the court appointed attorney if I can.
Well, you told me at the last setting that you wanted to hire an attorney.
I'll around. I can do it.
Okay, who'd you call and ask?
So, oh, right.
Be the only one?
So, chill. I can do it before.
Do you have any money saved up?
You know, I gotta look at it, like, I don't have enough money to. Right, to this,
How much money do you have saved up for your attorney?
then I got like $1,000.
Okay, and you talked to them to find out what their fee was gonna be?
So,
And you don't believe that if the court resets you one more time, that you'll be able to get up enough money to hire either one of them?
so if I can, I already decided on the court, sir.
Do you have a job? You working? So you may not, court appointed attorney is not an option. It is a right that's given to those who are indigent, who don't make enough money, who don't have jobs. So I'll let you fill out the application for court appointed attorney with Ms. Tabraham here, but there's no guarantee that you're gonna meet. And if you don't meet, then you're gonna be in the position of either have to hire an attorney or represent yourself, which is not advisable, okay? So step in the hallway, Ms. Tabraham will bring you some paperwork, fill that out. You may.
One head, just wait real quick, and I think we're still waiting on that front page of this work.
Mr. Gonzalez again. Mr. Strong. Mr. Chavez. Come on, sir. This is the sanctions court hearing. All right, Mr. Chavez, at the last sanctions court hearing, court ordered you to do a couple of things, pay your probation fees, pay your collection fees, work 10 hours community service. I see that you complied with all three of those. I think there was an issue with you submitting your payment on the 31st. I see that.
Reference. I just made a copy, just in case.
Yeah, well, that was smart. I do have that note here, so just make sure next time you put that in there and then you won't have any problems. So
Yeah.
court finds that you've complied with everything as I've ordered you to do. I'm gonna order you to do the same thing next month, and we're gonna continue to do this until you get to where you're doing this consistently. I don't have to worry about you, then we'll put you back on regular probation. You know, just regular reporting to probation. So at this time, I'm just gonna go ahead and reset you to May. Remind me about your work schedule.
That's great.
Okay, so let's do May 25th at 9 AM. And so you're gonna have to do $120 to probation, $120 to collections, and 10 hours of community service. Okay, make sure you get all that paid in before that. Now, that's more than 30 days. Okay, so make sure that not only are you meeting the minimum, but you're also preparing for the next month to do those same things. Does that make sense? Okay. All right, Deputy Police, she's gonna have you a notice of setting. We're gonna reset you to May 25th. Free to go. You're free to go.
Sorry.
All right, Ms. Price. All right, this is a sanctions court hearing at CR 2188. Ms. Price, you had 3 sanctions from our last setting. You were to pay $60 to your probation, to the probation office, $65 to the court collections, and work 10 hours of community service. My records showed that you did one of those 3 things. You worked your community service, but you didn't pay any of your fees.
That is when I paid it, I paid probation.
You paid to probation yesterday. How much is it? How much is that for?
This one's for the court was $66 and the probation I paid 60.
Okay. How come you paid yesterday and not last Friday? It was due by last Friday.
I got paid on the third, I get a monthly check.
Okay. All right, and you said you got your receipts for those things?
I've got this receipt there, it's online.
Okay.
I paid online, but I've got a receipt for the court.
All right, so what I'm gonna do, same thing I did for Mr. Chavez, I'm gonna continue to bring you back this price until we get a good solid foundation of you doing this every month and meeting your requirements. Once I see that you're able to handle those things, then I'll just let you go back to reporting over there without having to come to court. So right now, I'm gonna go ahead and reset you for May 25th.
You like the receipt, sir?
No, I'm gonna take your word for it. And then you're gonna show the probation officers and it's gonna go in their records, okay?
Okay.
I don't think you would lie to me, would you?
No, sir.
Okay. So next month, it's the same things, pay $60 to probation, $65 to collection, 10 hours of community service, and we should be after your pay periods where you won't have that issue, okay?
Okay.
All right, come over here and meet with Ms. Burns. Let's try Mr. Gonzalez again.
Just wrong.
Sure, we don't have any different luck. Oh, we are gonna have some luck, because now he's trying to connect audio. There we go. All right, Mr. Gonzalez, raise your hand if you can hear me now, can you? All right, so listen, I'm going to prompt you to unmute. I need you to push that button here. There you go. All right, you can see and hear me now?
Yes, sir. Yes, sir.
All right, excellent. All right. For the record, go over here to the case. This is cause number CR 22374, CR 22375, State versus Eugenio Gonzalez Merlo. We're set for docket call. The court is allowing Mr. Gonzalez to appear via Zoom today at his attorney's request. Mr. Estrada, we are set for docket call today. Any announcements?
Judge, we would ask for one additional docket call. I've shared the discovery with co-counsel Stephen Amster. There were some technical issues that have since been resolved regarding access to the discovery. And so we would ask for one additional docket. A offer, I believe, was relayed last week to Mr. Amster. I don't know if that offer's been relayed over to Mr. Gonzalez.
And remind me of the counsel. Is Mr. Absher, is he licensed in Texas and Florida or just Florida?
Just in Florida, Your Honor. So I serve as local counsel.
And so if a trial becomes necessary, is he going to be asking for admission to Texas court to try the case? I guess what I want to know is who is the lead attorney that's going to be determining what happens here in Texas?
Based on my conversations with Mr. Amster, he'd be requesting to appear pro hoc vice, Your Honor.
All right, court will grant any objection from the state on the request for an additional docket call.
No, Your Honor.
All right, court will set Mr. Gonzalez for an additional docket call. Do you believe that more than 30 days is required?
I believe 30 days to be sufficient, Judge.
All right, today is April 4th. Let's look to set this on May 9th for docket call. That'll be at 9 a.m. Mr. Gonzalez, you were ordered to appear in person today in court. Mr. Estrada appeared earlier. He indicated to the court that there was some confusion on when you were supposed to be here this week or next. So I'm not going to do a judgment nisi and issue a warrant for you for failing to appear today. However, I am going to order you to report here in Texas to my pretrial release officer. And you need to do that before Thursday of this week, before noon. So listen, their hours at the pretrial release department tomorrow are 7 a.m. to 4, 7 a.m. to 4 p.m. And then on Thursday from 8 a.m. to 11 a.m. You need to report over there to the pretrial release office, sign conditions of pretrial release. These are going to be conditions that you have to abide by while you are on bail. In this case, you're going to have to report, drug test, do those things. Do you understand that?
Understand a little. Understand a little. I'm sorry. Need somebody translation.
You need somebody what?
The translation in Spanish.
You need a translator.
Yeah, I don't understand too much.
Okay, well, I want you to understand this. I want you to report here to this court between 7 a.m. or between 8 a.m. and 4 p.m. tomorrow, or between 8 a.m. and 11 a.m. on Thursday. If you do not report, then the court's going to issue a warrant for your arrest for not being here today as ordered. Okay, you understand that?
Yeah.
Okay, all right. If you have any questions about it, call your attorney, Mr. Estrada, and he will give you more information.
Okay.
Okay, all right. All right, so the court's admonished the defendant to appear to the pretrial release officer between the hours of 8 and 4 tomorrow, or 8 and 11 on Thursday, and has reset Mr. Gonzalez's hearing on the docket call to May 9th. All right, so you're free to go at this time, Mr. Gonzalez.
And Judge, we will reiterate it through my staff after this hearing.
Thank you, Mr. Shaw. All right, thank you, Mr. Gonzalez. You're free to go.
Okay, thank you, sir.
You're welcome.
Judge may be excused.
Yes, thank you, and I appreciate your help. Mr. McSpadden, come on back up. All right, let the record reflect. This is cause number CR 2236, State versus Guy Ezekiel McSpadden. The court was conducting the plea admonishments, and the court had announced the proposed plea agreement. And then the court realized at that time that there was a legal issue in the paperwork. The court conferred with the attorney for the state and the attorney for the defendant. And we all agreed that the proposed plea agreement was actually illegal and prevented the court from assessing the sentence that was proposed. So at this time, I believe that the state has renegotiated a plea agreement with the defendant. And now the offer and plea agreement would be based on the state making a recommendation that a finding of guilt be deferred in this matter, that punishment be deferred, and that Mr. McSpadden be placed on 6 years community supervision with a $2,500 fine, $290 court cost, and $35 reimbursement fees. Mr. Stevens, have you explained the change in the plea agreement and the potential collateral consequences with changing from what we had before, which was a straight probation, to what we have now as a deferred probation 2-year plan?
I have, Your Honor, gone over those, gone over the pros and cons of deferred probation. He fully understands that should his probation be violated, he now stands before the court, the full range of punishment be available to the court versus the previous set punishment. And he also knows the benefits of successful completion of his probation, and I've explained all of those pros and cons to him.
Mr. McSpadden, do you understand what has occurred today in the changing of your plea agreement?
Yes, Your Honor.
And if the court were to follow this plea agreement and place you on community supervision, I want you to understand that if you violate any of the terms and conditions of your community supervision, the state can file a motion to adjudicate your guilt, which means a motion basically to convict you. The court could do several things. If it heard evidence that you violated your conditions, the court could adjudicate you, find you guilty. The court could revoke your community supervision, and then the court could assess your punishment. As Mr. Stevens said, anywhere within that range of punishment from a minimum of 2 years all the way up to the maximum of 20 years. You understand that?
Yes, Your Honor.
And understanding the change of your plea agreement, understanding the potential benefits and also the potential disadvantages, as Mr. Stevens spoke to, you still wish to go forward in this matter?
Yes, Your Honor.
Okay. All right. So at this time, Mr. McSpadden, I would ask you, I think I asked you before how you pled to the offense, but out of an abundance of caution, I want to go through these steps again. Okay. Mr. McSpadden, then how do you plead to aggravated assault with a deadly weapon?
Guilty, Your Honor.
And are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, Your Honor.
Has anyone pressured you, threatened you, or forced you to plead guilty to this offense?
No, Your Honor.
All right, the court will accept the defendant's plea of guilt. I don't believe the court made a finding earlier convicting Mr. McSpadden or making any findings on the deadly weapon. However, if the record in any way reflects that the court did convict Mr. McSpadden or make an affirmative finding on the deadly weapon, the court is withdrawing that at this time. The court, having reviewed the plea agreement, hereby accepts the defendant's plea of guilty. Mr. Stevens, any objection to the state's evidence supporting the plea?
No objection.
All right. And the court recalls Ms. Curry announcing to the court that there was victim notification and victim compliance and that the victim was supportive of the proposed plea agreement. The plea agreement has changed. However, the general terms have not changed with regards to what the court would be concerned about, which is a probated sentence. The court finds that the previous sentence is probated and this sentence is deferred. So the court will find that states in victim compliance and that the victim is supportive of this plea. Having reviewed the evidence, then the court finds that there is sufficient evidence to convict Mr. McSpadden of this offense. However, the court will follow the plea agreement. Court at this time defers a finding of guilt for Mr. McSpadden on the offense of aggravated assault with a deadly weapon. Court will defer a finding on the deadly weapon. The court, following the plea agreement, places Mr. McSpadden on 6 years community supervision, orders him to pay a $2,500 fine, $290 in court costs, $35 in reimbursement fees. The court hereby forfeits a weapon used and seized in conjunction with this offense, namely, as indicated on the judgment, a black Glock semi-automatic 40 caliber pistol. Court orders that that is forfeited to the Van Zandt County Criminal District Attorney's Office. Mr. Hartwell, do you know if there are any specific probation conditions regarding the victim in this case? Is there any prohibition? Ms. Curry indicated that this is a family matter. I tried to connect some of the dots in reviewing the evidence. Or Mr. Stevens?
I can, the alleged victim is a stepdaughter. She's now in college on scholarship. He raised her as its own. They completed the CPS case and there's no restrictions to CPS. I think they're all in a good place right now, but she's off in college and doesn't primarily live with him anymore, but through CPS and he's completed that successfully. They closed with no conditions through CPS. So we've never discussed any restrictions. And I think given the circumstances that it won't be an issue. They're in a good place.
Okay, thank you, Mr. Stevens.
Yes, Your Honor, I don't see any specific notes regarding the contact from in the site file.
All right, thank you. All right, then the court hereby remands Mr. McSpadden to the custody of the probation department so they can carry out the terms and conditions of the sentence. Mr. McSpadden, if you'll come forward and be fingerprinted by Deputy McLeish, then Ms. Burns will give you more information about probation.
Complete my business. Thank you.
Yes, thank you. Appreciate your patience. Thanks for your help.
Yes, sir. Thank you.
Joshua Martin. Sanctions coordinator. All right, this is sanctions court hearing in CR 19-180, State versus Joshua Mac Martin. Let's see here. I've got a note here. It says that counseling non-compliance, failing to attend as required, no attendance in January, and failed to attend all appointments in February. I've got a note regarding relapse. Unfortunately, there's gonna have to be a sanction for consumption of alcohol with. And I appreciate that. I appreciate that, but you know the position that I'm in. So what I would do is I would sanction you 3 days in jail. I'll let you pick those 3 days. It could be a weekend, you're not working, or however you want to do that. So that would be the sanction. If that's something that you're willing to accept, then we'll put over here meeting with Ms. Burns. She'll give you the dates. You'll give her the dates. She'll bring me an order. We'll sign that. And then we'll reset you after that. I'll reset you to after the time that you do your jail. Okay, so go over here and see Ms. Burns. Whatever date. Sanction court having. Anya McBride. This is sanctions court hearing in CR 2135. Let's see, Ms. McBride. Let me read your notes real quick. Sorry. All right, Ms. McBride. I want to recap your probation. So you're on deferred adjudication for a third degree felony theft of property between 30,000 to 150,000. Probationary period began December of 2020 and it runs for 10 years until December of 2030. Your conditions of community supervision include restitution to your victim. And your restitution amount is a significant amount. Shows that right now you're delinquent in your restitution payments. And that total is, the total delinquency is over $26,000. So I know that's a lot. You also owe court costs. My notes here say that you've made random payments since February of 22, but you've you began consistent payments in January and February of this year, but your payments have not been over $200 since being placed on probation. Your probation amount each month is $1,000. 955 of that is your restitution to your victim. And your victim is wanting to receive the money that they are owed. And they're wanting to know why you're not paying it. We're going to talk about that. Also, I have a note here that says that you're not working your community service. So I want to remind you that a deferred adjudication means that if you do not comply with the terms and conditions of your community supervision, you could potentially face a motion to adjudicate, which is a motion to convict you of the offense, to revoke you from probation, to put you in prison. And the court, if the court found that evidence was that you were not complying with your probation conditions, court could sentence you anywhere from minimum 2 years all the way up to the maximum 10 years in prison. Okay. So I just wanted to recap all of that. Now, tell me what you're trying to do regarding getting your restitution paid off.
So as far as payments, I did speak to competition. Budget, we get minimums, payment and more, that doesn't include fees and case pressure. And then with community service, I have not somebody that works with my schedule, so I'm working.
Okay. So you feel like you now have a plan of action on how to get your community service hours, because doing your community service is just as important as paying back your victim. All these conditions are equal. Sometimes I know probationers will push one to the back burner while they focus on the other. Unfortunately, it doesn't work like that. You have to meet all these conditions at the same time. So I see that the probation department has agreed to reduce your probation fee from $60 a month to $25 a month to try to get more money towards your restitution. So I see here that the probation department doesn't have to do that, but they're willing to do that because they're trying to help you. So if anything, when you walk out here today, you should know that your probation officer is actually trying to help you comply. Sometimes probationers think that the probation officers are just out to get them. And I don't believe that to be the case. And we have evidence in this case that they're trying to help you. All right. So what we're going to have to do in sanctions court, purpose of sanctions court is to monitor your compliance to make sure that you don't fall too far behind or get too far under that you give up and, have to face prison time. So I'm going to bring you back to court for a period so I can monitor how this new plan is going. Okay. And if you fail to comply with your conditions, there could be some consequences such as jail time as a sanction, increased probation, community service. There could be classes, there could be all kinds of things that I could add in addition to you to try to get your attention and make sure that you're complying. Okay. So this is your first time in sanctions court. So I'm going to reset you until May 25th. Okay. And what I want to see when you come back is I want to see a $300 payment to probation for your restitution plus your $25. So $325 to probation. And I want to see you pay $25 to the court costs. Okay. Because probation is taking care of their fees and they're taking care of the restitution to the victim, but you still owe on attorney fees or fines and court costs. So you need to pay $25 to court collections and you need to do that 10 hours of community service. Those are going to be your sanctions. If you fail to comply with those, then we're going to talk about that. The reason for the failure, if any, and then the consequence for the failure, if any. Okay, does that make sense? Yes, ma'am. You can do that. That's what we look for. I told a young man before you earlier, if you don't have all of that, you should be trying to take care of this for April. And then even though you're reporting at the end of May, you should already be working on complying for May. All right. So this isn't going to just take care of April and May. Unfortunately, you're going to have to do this every month in order to get off probation on time. And we may even have to ramp it up later, but this is where we're going to start. All right. So don't give up. Don't get down. Don't get frustrated. And definitely don't put your head in the sand and think it's going to go away, because it's not. Okay. It's better if something occurs, financial hardship or something, your first call should be your probation officer. All right. All right. So come on forward and meet with Ms. Burns here. She's going to give you some paperwork, perhaps. So let's have it. Mr. Dobbins, come on forward. All right, this is cause number CR 2158, State versus Randy Lee Dobbins. Mr. Dobbins, a motion to revoke your community supervision has been filed. The court has reviewed your application for court appointed attorney, and the court has found you to be indigent today for purposes of counsel. The court has appointed the Honorable Jonathan Manning to represent you. Mr. Manning is not here today. So what I'm going to do is I'm going to reset your case. I'm going to reset you to April 25th. And that'll be at 9 a.m. Mr. Manning will be notified of this appointment. I believe you have all of his contact information on that form. Give him a day or two so he can receive that and perhaps call the DA's office to get information on your case. So if you called him immediately today, he's not going to know who you are. He's not going to know anything about your case. It doesn't mean you can't call and introduce yourself, but you're going to have to give him time to get caught up, and we'll see you back on April 25th. Yes, you're free to go. Mr. Bowman. All right, Mr. Bowman, this is cause number CR 23-5. The court has reviewed your application for court appointed attorney, finds you to be indigent at this time with the ability to reimburse the county. The court has appointed the Honorable Richard Schmidt to represent you. Same information I just gave that other gentleman. We're going to have to communicate the appointment to Mr. Schmidt, give him time to contact the DA's office, find out more about your case. I'm going to go ahead and reset you. Sorry. I'm going to reset you to Tuesday, May 9th. Johnson is Thursday, Richard is Tuesday. she has his reset form, so I'm waiting for her. While we're waiting on Deputy McLeish to come back, she has your reset form. I want you to, you have your money saved up for the attorney that you're trying to obtain, okay? One of the conditions of your pretrial release is for you to pay for your court-appointed attorney, okay? So what I want you to do is I want you to go over and pay $500 to the pretrial release department towards your attorney. You have that money, go ahead and pay that. That way you get credit for that. If the case is, if you plea out later, then you won't be required to pay it at a later time. You'll have already satisfied that. Okay? Does that make sense? And so we're going to reset Mr. Bowman for arraignment on May 9th. That is a Tuesday. So Mr. Dobbin's already gone. That's okay. That's all right. I'll have Miss Tabraham contact him and perhaps we can change it to Mr. Manning's day. Slipped my mind. All right, once you get your notice of appearance, you're free to go. All right, Mr. Cheatham. Do we have that waiver of jury trial? Yes, sir. Trying to bring in Mr. Domin at this time. All right, this is cause number CR 22205, State versus Kalen David Cheatham. We are set for docket call today on the charge of evading arrest or detention with a vehicle. Any announcements, Mr. Domin? Mr. Domin, can you hear me?
I can't hear anything, Judge.
Well, I can hear you. Believe. You did.
Judge, what's going on? I have this turned down. Okay. Test speakers. Hello, 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 hello. I should.
Can you hear us now, Mr. Domin?
I can, Judge.
Excellent. Okay. All right. The court has called CR 22-205, State versus Kalen David Cheatham for docket call. Any announcements, Mr. Domin?
Yes, Your Honor, we've come to a plea agreement on the case, and I've signed a waiver of jury trial, which I've explained to Mr. Cheatham previous to his appearance just now. I anticipate him signing it. If we could set this for a plea, I believe the next criminal docket for the court is April 25th. Is that right?
Yes, sir. That is a docket date that is available. Okay, so at this time, I'm going, and Mr. Cheatham, can you see on that computer there? Can you see Mr. Domin there, your attorney? Okay. All right, Mr. Cheatham, I'm going to ask that you raise your right hand. I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower your hand. Your name is Kalen David Cheatham, is that correct? All right, and Mr. Cheatham, you have signed a waiver of jury trial document with your attorney, is that correct? And have you had enough time to read over this document to understand what it says? And you've spoken to your attorney about it? And he's indicated to court that he's explained to you what it means, is that correct? And you understand that you and only you can waive your right to a jury trial. The court can't make you do it. State's attorneys can't make you do it. Only you can do it, and it must be done intentionally, knowingly, and voluntarily, meaning that it's what you want to do, not what someone else wants you to do. So, and it's also important for you to understand that once you waive your right to a jury trial, and you may not get it back. If you decide at a later time between now and our next hearing that you want a jury trial, this document may prevent you from being able to get that back. Do you understand that? And after talking with your attorney, you're indicating to the court today that you want to waive your right to a jury trial. And you understand that when you waive your right to a jury trial, then you don't get to bring witnesses in front of the jury. You don't get to question the state's witnesses in front of the jury or contest their evidence in front of the jury. You understand that? All right, Mr. Dahman, you've counseled your client on the waiver of this jury trial. You believe that he understands it, correct?
I have and I do, Your Honor.
And you're joining him in this request?
I am, Judge.
All right, and also find that the state has also signed the waiver of jury trial, and the state is also waiving its right to a jury trial. Is that correct?
Yes, Your Honor.
Okay. All right, and on this waiver, I see two signatures. I don't know whose or whose. We're missing one. Have you signed this one yet, Mr. Cheatham? Okay, so at this time, I'm going to have Ms. Tapering bring this to you. If you understand that document and you want to waive your jury trial, then you're going to sign right there where it says defendant. All right, court finds that Mr. Cheatham has executed a waiver of jury trial, that he has done so intentionally, knowingly, voluntarily with the assistance of counsel, that the state has also waived its right to a jury trial. The court waives the defendant's right to a jury trial of the state. The court will set this matter for plea on, and you said April 25th, you're available, Mr. Dahman?
Yes, Your Honor.
All right, court sets Mr. Cheatham to enter his plea before the court on April 25th. That'll be at 9 a.m. And Mr. Cheatham, once you sign that notice of appearance there, we're going to give you a yellow copy and you are free to go. You're welcome. Thank you, sir. All right, thank you, Mr. Dahman. I will have this waiver of jury trial filed with the clerk.
Thank you, Your Honor. Am I excused?
Hey, you're excused. Have a good day.
Thank you, Judge. You too.
All right, it's kind of this waiver of jury trial. This one goes. Chavez. All right. All right, the court has called the case of Anthony Wayne Murray, CR 22336. Court finds that Mr. Murray is not present in court today when his name was called at 9 a.m. He's not present at this time, approximately 11:52 a.m. And court has received information from the bondsman that Mr. Murray may be in fact in custody in some detention center. However, court that's not been provided to the court, state's unaware of it. The court has done an online inquiry and there's no evidence of that. So at this time, the court's going to find that Mr. Murray has failed to appear. The court's going to enter a judgment not and alias capias. However, if that information does surface and Mr. Murray is in fact being held in federal custody, then the court will consider that in its side. All right, that concludes this morning's criminal docket. We will resume at 1:30 p.m. Same time, same channel.